Losing a loved one is undeniably one of the most difficult emotional experiences any family can face. While navigating your grief, the last thing you want to worry about is a stressful and confusing legal process. But unfortunately, many families must immediately transition from mourning into the complex world of Florida probate. If you are named as a beneficiary, you might be asking yourself just how secure your position is. Today, we are going to demystify beneficiary rights in Florida. But first, a quick reminder, this video is for informational purposes only and does not constitute legal advice. Consult a qualified attorney for specific legal guidance. Let us explore exactly what you need to know. When a loved one passes away in Florida, their estate often goes through a legal process known as probate. But what exactly does that mean for you as a potential beneficiary? Simply put, probate is the court-supervised procedure that ensures a deceased person's debts are paid and their remaining assets are correctly distributed. Think of it as a bridge between the decedent's past and the beneficiary's future. The process generally flows in a straight line, identifying the decedent's assets, settling any outstanding obligations, and finally, distributing the remaining inheritance to the rightful beneficiaries. In Florida, this entire process is overseen by a judge in the circuit court, specifically in the county where the deceased person lived. Because Florida is home to 67 counties, the exact administrative procedures and timelines can sometimes vary slightly, depending on the specific local jurisdiction handling the estate. Understanding this foundation is your first step as a beneficiary. When navigating Florida probate, beneficiaries will encounter one of three distinct paths, dictated largely by the size and complexity of the estate. The most common, yet most extensive, is formal administration. This is the standard probate process. It is required for estates valued at over $75,000. Because it involves appointing a personal representative and thorough court supervision, formal administration takes longer to complete, often stretching for several months. A faster, more streamlined alternative is summary administration. To qualify for this path, the total value of the Florida estate must be $75,000 or less, or the deceased must have passed away more than 2 years ago. Without the need to appoint a personal representative, the court simply issues an order distributing the assets directly to the beneficiaries, making it highly efficient. Finally, disposition without administration is a rapid, limited procedure. It applies only when the deceased leaves no real estate, and the remaining assets are just enough to reimburse the person who paid the final funeral and medical bills. Ultimately, the size of an estate heavily dictates the administration type and exactly how long a beneficiary will wait. Before diving into your rights in Florida probate, we need to identify the key players involved. Understanding who does what is essential. Let's break down the 4 main roles. First is the decedent, which is simply the legal term for the person who has passed away. Next is the personal representative, often called an executor. This person is appointed by the Florida probate court to manage the estate, settle debts, and distribute the remaining assets. Then we have beneficiaries and heirs. While often used interchangeably, there's a crucial legal difference. A beneficiary is specifically named in a will or trust to receive an asset. An heir is someone entitled to inherit by Florida state law when a person dies without a will. Finally, we have the creditors. These are the individuals or businesses the decedent owed money to at the time of their death. Under Florida law, valid creditors must be paid from the estate's assets before any beneficiaries or heirs receive their inheritance. As a beneficiary in a Florida probate case, you are not left in the dark. Your most fundamental right is the right to information. This begins with the Notice of Administration, which officially alerts you that the probate process has started. You are also entitled to receive a copy of the will itself, provided one exists. This allows you to read exactly what the decedent intended and verify your standing in the estate. Within 60 days of their appointment, the personal representative must provide an inventory of assets. This document gives you a clear picture of what the estate owns, from real estate to bank accounts, and their estimated values at the time of death. Finally, before the estate can be closed, you have the right to a final accounting. This detailed financial statement tracks every penny entering or leaving the estate during the probate process, ensuring total transparency and accountability. As a beneficiary in Florida, your rights aren't just theoretical, they are actionable protections. First is your right to a timely distribution. Florida law requires the personal representative to move the probate process forward efficiently. While the timeline varies depending on the estate's complexity, you shouldn't be left waiting indefinitely without justification. If you suspect undue influence, fraud, or lack of capacity, you have the right to challenge the will, but the clock is ticking. In Florida, you typically have just 90 days after receiving the notice of administration to file a formal objection. Miss this critical deadline, and you may lose your chance to contest the document entirely. Finally, what if the person managing the estate is failing their duties? Beneficiaries have the power to petition the court to remove a personal representative. Valid grounds include mismanagement of estate funds, severe conflicts of interest, or simply failing to comply with court orders. Don't assume everything will resolve itself. Ultimately, these actionable rights mean one thing: proactive vigilance is your absolute best tool to protect your rightful inheritance. So, you are a named beneficiary in a Florida probate case. Just how solid are your rights? Well, it is often a delicate balancing act. Let's look at the key factors that tip the scales. On the side of solid rights, we have a best-case scenario. This includes a clearly written, legally valid last will and testament, alongside a solvent estate that holds plenty of liquid assets. But on the other side of the scale, your rights can become less solid. If the will faces legal challenges, or if the estate lacks the funds to cover its obligations, your inheritance is at risk. Estate solvency is a major factor. Under Florida law, creditors have priority. If the deceased left behind significant medical bills or credit card debt, those must be settled before you receive anything. Finally, the actions of the personal representative and the complexity of the estate matter. A disorganized executor or tangled business assets can delay the process and weaken your rights. Even if a will seems rock solid, Florida law has specific protections that can alter beneficiary status. First is the pretermitted heir. If a person writes a will and later has or adopts a child, that child is often entitled to a share of the estate, regardless of the original document. Next is the spouse's elective share. In Florida, you cannot entirely disinherit your spouse. A surviving spouse has the right to claim 30% of the elective estate, which includes both probate and many non-probate assets, even if the will leaves them nothing. Finally, there is the Florida homestead exemption. This powerful constitutional protection ensures that a primary residence is preserved for their surviving spouse and minor children, overriding any conflicting instructions written in the will. To ensure your beneficiary rights are protected in Florida, you must take a proactive approach. Start by obtaining a copy of the will or trust document. This is your foundation for understanding what you are entitled to receive. Next, carefully review all notices from the personal representative. Keep a close eye on the calendar and monitor the progress of the probate administration to ensure court deadlines are met and the estate moves forward. Make it a priority to attend important court hearings. When the final accounting is presented, examine it closely. If anything seems incorrect, hidden, or missing, you have the legal right to file a formal objection. Finally, the most crucial step is consulting an experienced Florida probate attorney. They can help you navigate complex legal procedures, advocate for your best interests, and take decisive action if your rights are ever threatened. Understanding Florida probate costs and timelines is crucial. Typical expenses include attorney fees, court costs, and personal representative fees. The total cost largely depends on the estate's overall complexity. For the timeline, the process starts with filing the petition. Next is the notice to creditors, requiring a 3-month waiting period. This is followed by inventory, accounting, and finally, asset distribution. While formal probate usually takes 6 to 9 months, disputes or complex assets can extend this timeline significantly. Importantly, beneficiaries must be aware of the strict 90-day window to formally challenge a will once the notice of administration is provided. Navigating probate in Florida can feel overwhelming, but you don't have to go through it alone. Remember, understanding your rights as a beneficiary is the first and most important step to finding peace of mind during a difficult time. If you found this video helpful, please like, subscribe, and share your thoughts in the comments below. For more comprehensive resources or to find a local probate court near you, visit funeralus.com today. Please keep in mind that this video is for educational purposes and does not constitute legal advice. Always consult with a qualified attorney for your specific situation. Thank you so much for watching, and take care.